All right. We want to give folks just a second to come and join us here. Sherri, how long have you been with ADF?
Since January of 2020.
Okay. That's a lot's happened, I'm sure, in 12 years.
Such a, just a crazy time to join. It's just been awesome.
Good. Yeah. You probably thinking back to 2020, what the issues were that were big pressing issues. I'm sure it was probably laughable by today's standards.
Yeah. Well, I started, and then in March, the world shut down.
Right.
And we've just been on a, trajectory this way ever since that happened.
Yeah.
It's just, these major events. So.
Yeah. Well, you're in a good spot. We're certainly glad to have you here. Yeah. And Darren, how long have you been involved with ADF?
About a year now. So.
Okay. Well, we're going to do a formal invite here. Let me actually go ahead as I'm just chatting with everyone. I want to welcome you. Thanks for taking your lunch hour to join us here. I'm Davey Owens, Executive Director of the SCL. We've got I think a very timely topic for today, looking at really what's happening in the changing legal landscape. As I was just saying to Sherri, things are happening fast. They're happening all the time. And I know as I talk to heads of schools every day, there is definitely up there on the top list of concerns is just keeping an eye on what's happening. It's hard enough just running the school inside of the day-to-day operations, much less keeping an eye on all of these things that are coming at us, if you will. So we're going to talk here in just a moment about Title IX and how does that matter for schools, talk about federal funding and how that may be changing, all these terms that we keep throwing around, trying to get definitions, religious exemption. There's just so many things. We really need 2 hours, but we promise we're going to get this done in 1 hour. Before we get started with our formal time with Sherri and Darren, just again want to welcome all of you. Say thanks for being a part of the SCL. I know a lot of you on the call are members of the SCL. We're continuing to add tremendous value to our institutional membership, and just want to encourage, if you're not a member school, to join us. There's a link in the chat area. One of the benefits, and I was just saying to Sherri, really impressed, you guys are officially part of our strategic partnership, our sponsors out there, and you guys is one of the benefits is if you want to avail yourself of the services of ADF, which I strongly encourage schools to look into. There's a discount that comes for being an SCL member. So that's just one of many things that SCL membership provides. And ADF is an amazing organization, Alliance Defending Freedom. We were just chatting again. You guys have 84 full-time attorneys with a network of 3,700. You've played a role in 65 plus Supreme Court victories. That I'm sure there are stories we could just tell for the next hour, which would be fascinating, of all the work you're doing. But you guys definitely have your ear to the ground on what's happening, and we appreciate your sponsorship. We appreciate you guys being on the call. Just a couple other quick housekeeping matters. One of the other, I think, success stories of the SCL in the last year and a half have been the growing number of cohort groups and workshops trying to convene people that normally are in schools separated from each other. So if you're an academic leader or dean or a head of school or an athletic director, we convene you in these monthly online meetings with a senior mentor. It's a great way to be connected, to be resourced. All those details are also on the SCL website. And then finally, just kind of housekeeping. So I'm going to turn it over to Sherri and Darren here in just a moment, and then they're going to do a presentation. There will then be an opportunity for Q&A. So as they go along, if you have a question, you can put it in the Q&A box. And then we will have a time where we will invite you, if you want to jump into off the kind of gallery or into the gallery with us, where you can actually turn on your camera and ask the question, or if you're more comfortable just typing that in, that is certainly fine as well. We are recording the call today, which will be helpful for those who weren't able to make it. All right. Well, with all that being said, I'd love to say a prayer for us, and then I'm going to introduce Sherri and Darren. Let's pray. And I want to pick a prayer that goes back throughout the centuries. This is a prayer for dependence on God. And I thought, in light of today's call, there's a lot of things that we're talking about that we need to do in our humanness to shore up our schools and to protect them and to be wise. But there's ultimately our dependence on God. So this is John Calvin's prayer for prayer of dependence on God, a short prayer, if you'll pray with me. Almighty God, we ask that we may learn, whether in want or in abundance, to submit ourselves to you, and that you may be our only and perfect source of happiness, to depend on you, to rest in your salvation, and the experience of which you have already given us, until we reach that eternal rest when we shall share the joy in all its fullness, when we're made partakers of the glory which has been procured for us by the blood of your only begotten Son. Bless our time together today in Jesus' name. Amen. Amen. Well, if you've not met Sherri, just again, by way of introduction, Sherri serves as the Regional Alliance Director and the Church and Ministry Alliance with the Alliance of Defending Freedom. Sherri's been in this role for 12 years, we were just talking about, and does so much to help churches and schools manage in the light of the changing landscape around us with the Church Alliance. And again, Sherri, maybe talk more about that. She's coming to us today from Arizona, where she's served on the board and prayer team of her Church Without Walls there. She's been married to her husband, Carrie, 25 years. They have 2 children and an 11-year-old grandson. So Sherri is kind of one of us in the sense of being a parent, being concerned about education. And I want to introduce Darren Keys. Darren is actually live right now from the Covenant School there in Fort Worth, where he has also very much involved with his parent hat on. 5 of his 6 children attend Covenant School. He's senior counsel. He assists ADF with church and ministry clients while helping to protect their religious freedom. And he's also been actively on the board there at Covenant. So couldn't have 2 more capable and competent folks to bring us this information today. So I'm going to officially turn it over to you, Sherri, and Darren. Thank you for joining us.
Okay, thanks so much, Davies. We're just thrilled to be here with you all. So let me go ahead and share my screen. So first I'll talk about the agenda today. So I'm going to give you just a brief history on the vision and mission of ADF. Then we're going to move into religious liberty threats. Darren's going to speak about Title IX and other threats that are facing Christian schools. I'll talk a little bit about our partnership. And then Darren's going to go into some detail about how we serve Christian schools through our document review process. And then we're going to open it up for questions. So with that, I'm going to get started. I think we can all agree, we all know that the culture has changed. And so when the culture changes, laws change. And when laws change, it can really impact your ability to do what God has called you to do. You know, we know that today, the culture in the government is pushing a worldview that really promotes victims. It pits people against each other, and it's definitely trying to destroy any distinction between male and female, and also trying to take away parental rights. So let me give you an example of this. So about 1.5 years ago, this is a story in the New York Times, and it was after a legal battle, but it's the first time 3 people were named on a child's birth certificate. So I highlight this for 2 reasons. First, I think it shows the magnitude of the harvest field. But second, you know, we face a spiritual enemy, and one of the tactics that he uses to shut down the voice of religious freedom is through the legal system. And so that's why the work of Alliance Defending Freedom is so important. So our mission, the reason we exist, is to keep the doors open for the gospel, and we advocate in 3 areas: religious liberty, sanctity of life, and marriage and family. We were started in 1993 by over 30 different ministry leaders. Here, who you see here are just some true generals of the faith. Now, interestingly enough, back then, just like we're facing today, there was a secular agenda that was trying to use fear, intimidation to really hinder the work of religious freedom. So ADF was born, and we wanted to reverse that trend by funding cases, training attorneys, and then successfully advocating for religious freedom in court. So I just want to share some history about our success. So since 2011, we've won 14 Supreme Court cases. Obviously, I want to highlight the last case was this past June, and that was the Dobbs case, where it was able to overturn Roe versus Wade. We've also played a major role in over 65 Supreme Court victories. And so what that means is we win 80% of the time. So the Lord is truly blessing the work of ADF. And like Davey said, I've been here since January of 2020. It's a very special organization. Everything we do is covered in prayer. The most important verse that we look to is John 15:5, and that is, apart from Christ, we can do nothing. So now what I want to do is we're going to move into religious liberty threats. And so I'm going to turn it over to Darren.
Great, thanks. Thanks, Sherri. And it's so nice to be able to join you all and feel like I'm with my people. So first, I think you can, Sherri, you want to turn to the next slide. Yeah, that we're going to talk about Title IX and what it means and why it matters. And so let's just start with some basics. Title IX is a federal law. It's passed in 1972. It prohibits discrimination on the basis of sex in any education program or activity receiving federal financial assistance. So from 1972 until actually very recently, there wasn't really much debate about the word sex in Title IX. In fact, at the time of its adoption, everyone understood that the legislation was designed primarily to protect young girls and women in their pursuit of equal opportunities and equal access to education. And on January 8, 2021, and note the date, the Department of Education's legal office issued a detailed memo that supported the Department of Education, or DOE, I'm going to refer to Department of Education as DOE throughout this, supported the long-standing construction of the term sex under Title IX to mean biological, male or female. And as I noted, that was January 8, 2021. Everything changed a few days later when the Biden administration came into the White House. And President Biden immediately issued a directive to all federal branches of government, ordering them to expand the definition of sex in all non-discrimination policies to encompass sexual orientation and gender identity. We refer to this as SOGI, sexual orientation, gender identity. So since the president's executive order that happened on January 20th, 2021, the day he came into office, there's been a domino effect across various federal branches as they have taken steps to comply with the executive directive. The DOE took swift action to issue a, quote, notice of interpretation regarding its position interpreting the Bostock decision. You may have heard about that in 2020, and they extended it to Title IX. Now, Bostock was a Supreme Court decision, as I mentioned, in 2020 that addressed the definition of sex in Title VII that relates to employment discrimination cases. And the court expressly, in its opinion, declined to extend the reasoning of the opinion to other statutes, such as Title IX. But nevertheless, DOE piggybacked off the Bostock decision and proclaimed it would now start enforcing Title IX to mean discrimination on the basis of sex, including SOGI. So after the notice of interpretation, DOE issued a fact sheet warning schools it would launch an investigation if a school prevented a student from joining an athletic team or using the restroom corresponding to that student's gender identity, or if the if students refuse to use students' preferred pronouns. And most recently, in just this past July, DOE finally released its proposed set of Title IX regulations and opened them to public comment. And once enacted, the new final rules will officially expand the term sex to encompass gender identity and sexual orientation. ADF challenged these rules by filing 5 sets of formal comments, and DOE received a number of public comments, nearing 240,000. So now they have to take time to review those, and that could take many months. So next slide, I believe. So, but there have been some encouraging signs, and courts have done some things to help Christian schools. As we wait on the Department of Education to issue their new rules, where are we left? It's a big mess. We only have unofficial guidance. There's no clear direction for schools to follow, and there's lots of litigation that's reaching different outcomes in different jurisdictions. If you were to follow the Biden administration's reinterpretation of federal law expanding the term sex, what would that look like? It would require schools who are subject to Title IX to allow males who identify as female to participate on female athletic teams, use female designated showers, bathrooms, and other intimate spaces, and so on. And, you know, just imagine the implications for overnight school trips and similar accommodations that are traditionally separated by biological sex. That would all be out the window as an illegal form of discrimination based on subjective gender identity. And importantly, I think even if you're a religious school covered by Title IX's religious exemption, we're going to talk about that more in just a moment, you may find your female athletes at a competitive disadvantage against public schools or other private schools who have biological boys on girls' teams. This takes us to a current case that I want to talk about. It involves ACSI. You may be familiar with the Association of Christian Schools International. ADF represents ACSI, along with 3 female student athletes from Arkansas as an intervener in a case in Tennessee. It's Tennessee versus the U.S. Department of Education, and 20 different states jointly filed a federal lawsuit against DOE regarding this matter. The lawsuit specifically challenged the legality of DOE's various guidance documents that were issued in response to the president's executive order. And the states argued that these were deficient under the Administrative Procedures Act and the Constitution. Good news is, actually the great news is, the judge agreed. The district court granted a preliminary injunction, which essentially suspends the challenged guidance documents, but only as to the 20 named plaintiffs in the case. So the judge refrained from issuing a nationwide injunction. But if you're in one of the lucky 20 states that filed suit, then you can rest easy for now. That's a huge win, but it's only temporary. The case is currently stayed while it's on appeal to the 6th Circuit. And meanwhile, once the DOE finalizes the new Title IX rules, this litigation effort will shift to a challenge of the new regulations. And all of this unofficial guidance is going to drop off as moot. So we'll basically have to start over at that point. Next slide. Yeah. So speaking of religious exemption and how it works, here's one of our recent cases. This case, Grant Park Christian Academy, involves the U.S. Department of Agriculture and its lunch programs. What happened was on May 5th of this year, the USDA Food and Nutrition Service announced its intention to interpret the prohibition on discrimination based on sex in Title IX to include the SOGI language. And they published a memorandum to this effect, citing Bostock and as I mentioned, relates to Title VII, but they used it as the justification for their Title IX interpretation. As a result of the USDA's action, what started happening was USDA was rolling out new non-discrimination posters that contained updated sexual discrimination language, including SOGI language. And unofficially, we learned USDA was telling states that even religious schools had to use the new posters and had to update all of their non-discrimination policies to meet the new definitions. In response, our schools raised the Title IX religious exemption. And USDA said it recognized the religious exemption, but it was requiring schools to proactively apply for it. And meanwhile, while they were waiting an indefinite amount of time for a decision, they had to go ahead and comply with the new language and new policies. ADF immediately reached out to contacts within DOE and USDA to resolve the gross misunderstanding of how they were interpreting the Title IX religious exemption, but to no avail. So we found a client willing to litigate in the form of Grant Park Christian Academy, a small religious school in Florida that relies heavily on the USDA lunch program to feed its low-income student body. there was no way they were about to violate their religious convictions and change their non-discrimination policies. And they wanted to courageously step out in hopes of benefiting other schools. So on behalf of Grant Park, we sued, and it didn't take long. Once the DOJ and Department of Justice was involved to persuade the USDA to reverse its position on the religious exemption process. Thankfully, USDA posted an update on its website on August 12th, clarifying that schools don't need to proactively apply for the religious exemption. Even though this was a Florida case, it resulted in a major victory for all religious schools across the country who no longer need to worry about being disqualified from USDA's lunch programs or being forced to violate their religious beliefs just to provide hot meals to their students. All right. But courts now have started to call into question a tax exempt status, and let's talk about what this means. And you might have some questions at this point. How does this affect me? And there are a couple of important threshold questions to consider. One, does Title IX even apply to you? And two, if so, doesn't the religious exemption solve my problem? First, how do you know if you're subject to Title IX? There's two parts to that analysis. One, are you conducting an education program or activity? And for everyone on this call, the answer is yes. So the second question is the key question. Are you a recipient of federal financial assistance? This number two question used to be fairly straightforward. We would ask, do you apply for or receive any sort of federal grant funds? For example, do you participate in the USDA hot lunch program or special milk program? Those things counted. But the analysis has recently become more nuanced. We're seeing aggressive efforts to expand the application of Title IX farther than it's ever gone before. Two issues currently being litigated involve the effect of the PPP loans under the COVID Relief Acts, and believe it or not, your 501c3 status. As to the PPP loans, just know that some courts have recently held that receipt of the PPP loans triggers Title IX application, but only during the window of time the school held the loan until it was discharged or forgiven. Hopefully that lowers the risk of the Title IX vulnerability to a relatively small window. A bigger concern involves two lower court decisions from just this past summer, one in Maryland and one in California, which each held simply having 501c3 status under the tax code was equivalent to receiving financial assistance, federal financial assistance, for the purpose of Title IX. This line of reasoning sent shockwaves really across the country to attorneys and CPAs alike. And ADF is closely monitoring both of those cases as they progress on appeal. But for now, these decisions are at a very local level. They're not binding in a broader sense, so there's no immediate need to panic. But if this terrible reasoning would be upheld at a higher level, then yes, the impact on private schools, Christian schools, could be astronomical. We don't have to cross that bridge until we come to it, though. So can the religious exemption, can this save us from the madness that's going on around us? Yes and no, only to an extent. It's true that Title IX contains within the statute a strong exemption for religious schools. And thankfully, it's true that so far the Department of Education has been good about acknowledging and applying the religious exemption. But importantly, the religious exemption does not cover everything. The exemption only provides that Title IX will not apply in instances where its application would conflict with the school's religious tenets. This will hopefully work to solve problems as to SOGI-related issues in the changing rules, think sports teams or restrooms, pronouns, and intimate spaces. But you're left with a much bigger problem, which is compliance with Title IX as a whole. And what does this all mean? A couple of things. One, you should make sure your religious beliefs are clearly articulated in your statement of faith or a doctrinal position statement, especially concerning marriage and sexuality. And two, you need to understand the full picture of your compliance obligations under Title IX. If Title IX is a big pie, the religious exemption will cover maybe 10 to 20% of the pie, but you will still be responsible for the remaining 80 to 90%. And full compliance with the current regulations is no small task. It's a very heavy lift. It's based on 2,000 pages of new regulations handed down just in August 2020. And the rules are incredibly prescriptive and require you to implement specific policies and procedures regarding sexual harassment grievance processes. This affects training, staffing, documentation, timelines, and many things. And importantly, there's a significant legal risk to your failure to comply with those steps. Things like a private cause of action, uncapped damages, catastrophic jury verdicts, and more. For these reasons, if at all possible, we typically recommend you avoid federal funds to avoid Title IX responsibilities altogether. If you can't avoid Title IX, it's important to know how the religious exemption works, and it should apply automatically by operation of statute. While the Department of Education will respond to a written request for assurance, it does not require you to submit any qualifying documentation or actually, quote, apply for the exemption. It can simply be raised defensively during a Title IX challenge. Sherri?
So I want to tell you about one more case, and then we're going to talk about how we serve SCL through our partnership. But this is Lori Smith, and this is a free speech case, and it's going to be heard at the Supreme Court Monday on December 5th. And it's kind of a unique story, and free speech affects everyone. So Lori Smith, she designs custom wedding websites. She's in Colorado. And there's a Colorado law that says if you promote one, so she promotes marriage through one man and one woman. So the law says if you promote one, then you have to promote the other, right? So she'd have to promote homosexual marriage. Now, if she doesn't do that, then the law says that she can be fined $500 for each violation, and her staff would have to go through re-education training. So we proactively filed a case on her behalf. It was heard at the 10th Circuit, and their decision is kind of an unprecedented ruling. So what they said is the more unique speech is, the more government can compel it. And so what that means is, as speech increases in uniqueness, you actually lose your First Amendment rights. So we're thrilled that this is going to be heard in December. And what the Supreme Court is going to be deciding is if a public accommodation law that compels an artist to speak or stay silent violates the free speech clause in the First Amendment. So this is critically important. So I wanted to mention that. And we will be sending out some resources after the call, and we do have like a short video so you can learn more about this case. So please be praying for it. So now we're going to move into our partnership. So we started the Church and Ministry Alliance in 2017, and really for three important reasons. One is we wanted to make sure churches and Christian schools could proactively protect their religious freedom. We wanted to ensure that they had access to both legal resources and legal representation without financial risk. And then the third is probably the most important, and that is to build an alliance across the country so that we can create an environment where spiritual boldness can thrive. So there's 4 key benefits to membership. The first is, and probably most important, is our document review process. And Darren's going to go into more detail about this. But this is where you send all of your governing documents, your bylaws, your handbooks, employment documents. Send that in to us. Our attorneys will review those documents, and then they'll make recommendations to ensure that you have the highest religious liberty protections in place. Bottom line is, if you ever face a threat, a religious liberty threat, then your core documents become court documents. The second is attorney consultation. So when you have a situation, a question, you're not sure what to do, we want you to call in, talk to one of our attorneys, get their advice, understand your rights before you take action. Third is when you join, you have access to a membership portal, and there are numerous resources inside the portal. So all of our documents are in there, all of the sample documents. We have a number of legal guides that you'll have access to, training, an example, media training, what you should do when the media shows up at your front door. And then we break down every case so you know how it applies to you. And then last is legal representation. So when appropriate and necessary, you have access to legal representation all the way to the Supreme Court without any additional cost. Again, this will be sent out after the call, but this shows how you join. So your school joins based on your operating revenue. It is an annual membership, so you can see the scale over there on the left-hand side, and then you can see what you pay. We do have a 20% discount with the promo code SCL20, and then you can see the pricing right there. And so now what I want to do is hand it back over to Darren so he can really talk about this document review process.
Thanks, Sherri. So yeah, the document review process is a core piece of how we serve Ministry Alliance clients. And what that looks like, Sherri mentioned, is we want to help you clearly communicate what your beliefs are, create the core documents so that you can state those beliefs, and then in writing, and then consistently apply those throughout your documents. And so frequently how this looks just in practical reality is that a school may send us, from I kind of refer to it as the hierarchy or pyramid of documents. At the top, the articles of incorporation, to the bylaws, to employee handbook, faculty handbook, student and parent handbooks, even admissions forms or policies, and other related policies that your school may have. We'll review those. We look to make sure that you have a good, expression of your core beliefs, and for certain beliefs in particular that address marriage and sexuality, and then to make sure that they're applied throughout your documents. I say that they trickle down through the other documents that flow out of kind of the core documents. So. Yeah, and one particular case I will mention, and this came up this summer, that some Christian school associations are supporting Yeshiva University. You may have heard about this case in the media, but over the summer in New York, a state trial court, this was the Yeshiva University Pride Alliance versus the university that and the state trial court in New York held that New York City's public accommodation law required the university to officially recognize a student organization, an LGBT group, as a student organization. And what was interesting about this was that yeshiva is incorporated under the New York education law. But according to the court, they said, quote, yeshiva's organizing documents do not expressly indicate that yeshiva has a religious purpose. Rather, it had organized itself as an educational corporation and for educational purposes exclusively. And that the inquiry must focus on the purpose of the institution, which is typically expressed in a corporation's organizing documents. I mention this because this is something we see from time to time in reviewing even the articles of incorporation of a school. This is on appeal. I'll mention this is on appeal to and actually ADF intervened. The university appealed to the U.S. Supreme Court, and the Supreme Court hasn't taken it up. They sent it back to the lower court, so it's still pending. But one of the key takeaways is that we need to make sure that at least the standard language sometimes that you'll see in 501c3 entities is that it says the corporation is incorporated exclusively for charitable, scientific, literary, and educational purposes. You guys may have seen that phrase, and we need to make sure that at least as a minimum before educational in that clause is inserted religious or religiously educational purposes. So that it's those types of things that we will look for when we're doing a document review, and that we can, help identify those issues. And regarding employment as well. So again, we'll look at employee manuals, faculty manuals, and make sure there's a statement of faith identified, your beliefs about marriage and sexuality articulated. We will also review your code of conduct. We actually also have a recommended code of conduct if you don't have one currently that we can help provide you with. And then we also emphasize we have some example job descriptions. I think this is interesting, particularly just personally. I always enjoy the sample job descriptions, but it's to help articulate and emphasize that every position on your school campus reflects the religious purpose and function of the role. And that's something we work to make sure that your job descriptions and your other employment documents emphasize the religious purpose and function of all your employees. We will also help facility use. If you own your property as a school and you may let other civic groups or other groups in the community use space, that's fine. But we recommend using a good facility use policy. We have a facility use policy that we can provide you with. It's our recommended form, but that can help minimize the risk that would arise otherwise by letting groups outside your school community use the property whose faith or beliefs may contradict your beliefs, because the facility use policy emphasizes that the facility may not be used in a way that contradicts your beliefs. And then also we can help with physical privacy and sexuality policy. If you want to go further and make sure that you have a policy in place to emphasize that your intimate space facilities like your locker rooms and restrooms can only be used by biological males and biological females, we can help with a specific policy in that regards and have a recommended policy to help with.
Okay, that really concludes our presentation, so we can open it up for questions.
Great. Thanks so much, Sherri and Darren. Marissa, if you want to, what we're going to do is just basically send an invite out that any of you on the call that would like to turn on your cameras and ask the question, that's always best because you can interact directly. If you're more comfortable posting that in the Q&A section, that is certainly fine as well. So we will open it up at this time. Not a problem. And give folks just a second to switch over. While we're waiting on folks to come in, I had one question, Sherri and Darren, maybe just we haven't talked a lot about school choice. I know it's kind of a hot topic right now out there, and I think we're all hoping that the winds blow in our favor, where parents are equipped with their tax dollars back in their hands to go pick schools that they choose. I know that's getting caught up right now in a lot of legislation debate, trying to sort it out. Where do you see that right now? Where is school choice as it might benefit us on the landscape?
Well, I'll address that. Obviously, it is very state specific. States are advancing that on different fronts. I'm in Texas. We don't have really school choice in Texas. There does seem to be an indication that it's going to advance in the upcoming legislative session. So as far as, the policy advancement, that's a very particularized state question. As far as it relates to schools, I will say that I think it depends on how, when you say school choice, that can, manifest itself in various forms. And whenever I've found myself talking to schools, Florida has some form of school choice program. Arizona just adopted a universal school choice program. But I think the important thing is whenever I do think it's overall positive development, but to be aware as a school in the state where you're at, how it manifests itself. And we just encourage schools to be aware that certain programs are not entirely string free. They may be, but not, the Florida one has a few strings with it. And so we encourage schools to be aware of the particular program that's been adopted by, the state that they're in. And we don't want schools to get overly dependent on funding that may be flowing through a state. The state may be administering the funding and able to attach strings. And if you become overly dependent on that revenue, that can create some problems. We've seen, we've seen that kind of percolate up just a little bit in Florida with some schools. So
okay, that's great, Darren. Looks like Christopher joined us here, and are there others that want to ask a question that are now in the room with us? All right. Greg Forrest just posted a question. He said, our school has considered pursuing a 508c1a tax status rather than a 501c3. Is this advisable? So does that any comments there, Darren or Sherri?
There's no, I don't know that there's any particular advantage of pursuing that. And I'm happy to discuss that further with, did you say Greg?
With Greg, yeah.
I'm happy to discuss that further. It's a bit of a nuanced tax code question, but right now I'm not aware of any kind of legal benefit of pursuing that, but it may also depend on the nuances of his question.
Yeah. Okay. Well, Greg, we can connect you with Darren on that for sure. Definitely an important question to get sorted out. Others with questions want to make, this is your time. Hopefully, yeah, there you go. Christopher's ready to go.
Is there any legislative effort that you're aware of to limit, let's say, the volatility or the capriciousness of executive interpretations of existing regulations? Like, should we expect in the long term that it's just going to depend on which administration is interpreting Title IX or whatever law it is? Or are there legislative efforts to kind of tighten this up a little bit and give us some predictability?
That's a great question. I'm not aware of any specific legislative efforts, and I'm not particularly optimistic about any specific legislative efforts if there were some. I would say, I think it's kind of the present situation we find ourselves in. The federal administrative state has just grown so large that I think this is going to be the reality. I do think you can see over the past 2 years, there have been a number of federal courts, federal district courts and appellate courts that have, I think, taken, issued good opinions to kind of rein in this administrative state that really has, it's a bit of a nerdy legal thing. It's very procedural, the Administrative Procedures Act. But it gets to how the executive branch can, in fact, adopt into rule certain procedures and policies. And courts have been pushing back on the executive branch in their violation of the APA in the past year or two. That is encouraging to see, but I don't know that I'm aware of any legislative efforts to do that. So.
Thanks, Christopher. Amy Walker's asked, does ADF anticipate that just by being a nonprofit tax exempt will constitute receiving federal funding, and as a result subject us to Title IX? And you talked a bit about that. Where do you see that going?
Yeah, so and that's a great question, Amy. I wish I had a crystal ball. I can say that what I talked about, where the Maryland and California courts, who just this summer adopted that reasoning in their court cases, we had kind of seen that bubbling up for years. I mean, you could read legal pieces, journal pieces and whatnot for years, people kind of making this argument that tax exemption was federal financial assistance and would trigger this. And so it's kind of been out there. We had not seen it manifest itself in actual court opinions until this summer. And so I think that's the troubling kind of aspect about this. What had kind of been relegated to, maybe the academy or, the internet or journal pieces is now being kind of, memorialized into court opinions. So that's troubling. Now, I don't think, as I mentioned, it doesn't, I'm not staying awake at night right now. It's not causing immediate panic. I do think, it's like the storm clouds on the horizon. And what do I anticipate? What does ADF anticipate? I mean, I think if this were to think with the current composition of the Supreme Court, if this ever made it to the Supreme Court, that particular issue, I think with the current composition, I would hope and have optimism that they would not, determine that 501c3 tax exempt status constitutes federal financial assistance for purposes of Title IX. But
Right.
I need a crystal ball to be able to answer for sure.
Certainly hope so. All right. Others with questions? So Sherri and Darren, I'm curious, given your work with schools, you did a great job kind of summarizing the kind of work that you do when you come in and shore things up. From your experience, what are some of the top most vulnerable things you typically find if there's a typical, especially in classical Christian schools?
I'll take it. Yeah. I'll tell you, to be frank and honest, I mean, I guess it kind of saddens me, but I haven't talked to a school or I've my surprise, like the transgender, the gender identity issues. It doesn't matter where you are. You could be a school in the most remote part of the country or in a big city. The gender identity issues are really presenting. I mean, the schools are on the tip of the spear as far as being kind of recipients of like having to deal with those issues. And like I think you mentioned in the introduction, I'm on the board of our school. Our kids go to classical Christian school. And I think the heart of Christian schools and classical Christian schools is to shepherd, and to care for their children, but also these issues present some really practical problems. And so I think that those are frequent issues. I mean, and if you've encountered that in your school, I would say you're not alone. I mean, a lot of schools are encountering that. And so I think that's a big area where we can help. We can, the privacy policy, making sure your statements of faith are clear on that, especially on sexuality. Marriage, we've had more years to kind of come to terms with. No one had heard very few people had heard the word transgender, until like 4 or 5 years ago. And so we're kind of playing catch up there to make sure that our belief statements articulate clearly what we believe on that. So.
And Darren, and again, I don't know if kind of following that question, I don't know if there's a common point of where that happens. Does it tend to be an existing student that decides they're going to, change gender and then they have an issue with the school? Or how often, because I could see too where outside folks are, trying to apply just to stir up trouble and create external folks coming in. Which is it both? Is it one more than the other?
Yeah, it's all, I'll tell you just briefly, one of the things that, and I talk to, these ministries, and it, every now and then it's just one grips my heart. And I was talking to a lady who was the head of a school in a rural area of the country. an area outside where you would think you would encounter these issues. And the issue was one of the students there, the parents had gotten divorced, and the dad thought he was now a woman. And and at pickup, the man would at student pickup time, would park on the far side of the parking lot and walk across everyone, walk through the parking lot in front of all these kids. It's like it was an elementary school.
Yeah.
And kind of flaunt this. And it just broke her heart. And I mean, and her heart, and it broke my heart to hear her, wrestling with this. And so we talked through what you could do in that kind of situation. What do they need to have in place? And so, I mean, to answer your question, Dave, is it
all the above,
manifests
right?
itself
Yeah.
in all kinds of fashion.
Right. Yeah.
So,
Just again, how can we be attentive to where these, chips in the wall or breaks in the wall might be? So that's good. Yeah. Pay attention at all. Sherri, were you going to make a
Well,
comment?
and this probably isn't fair to Darren, but I had such a hard question asked to me from a school regarding some of these issues. And so this is just in ways of disciplinary procedures. So obviously, and this is a K through 6, where, just display of affection between a boy and a girl, but then now they were faced with displays of affection between 2 girls or 2 boys, and the disciplinary actions that could take place in that. And so I've gotten that question a couple times. Sometimes we'll travel around and do workshops on the document review. And so that's where this has come up. So Darren, I was just wondering your thoughts on that. I'm sorry.
Let's talk. Can we talk about? I saw a question. I'm sorry. Let's. I work with Sherri, so I'm gonna.
That's
But
good.
I saw a question. I know we have a time limit, and I saw this question. I'm sorry. I just saw it. I was looking at this as Sherri was.
Yeah, go ahead,
Greg
Darren, on that. Yeah, we got about 7 minutes. So sure.
Yeah. So Greg asked a question about ERC funds being considered similar to PPP funds. That's a good question. And Greg, I think you're talking about the employee retention tax credit. That's what I'm going to assume by ERC. And that's a question we've been helping a number of schools with. And no, the short answer to the way you frame the question is no, I don't think they should be considered like PPP funds. The ERC tax credit being a tax credit, we actually typically historically have said that's fundamentally different even from financial assistance, a tax credit being something that like you're not giving the government something, and so that's not really financial assistance. So that's and it's offset to tax liability, and that actually historically, in fact, has not been viewed as federal financial assistance. So I think we're comfortable with schools taking the ERTC. That the cases I mentioned about the tax exemption, the 501c3 cases from the summer, that's cast a little bit of a shadow on that, because if courts are going to say tax exemption is federal financial assistance, then what does that mean for the tax credits? But honestly, we're in the risk assessment. I'd be more concerned about your tax exemption being considered federal financial assistance before I would be the ERTC. So, and since the 501c3 tax exemption, is just localized right now, it doesn't have, more of a appellate or higher court backing, then I think the ERTC is, we talked to schools about that, and very, very low risk and remote risk right now. So
Right.
Hopefully that helps, Greg.
Great. Darren, we got another question from Heidi Brown, PC.
Let's see. Okay, this is I don't know if everyone can see, but I'll just say she's
Yeah, go ahead and
saying,
go ahead and restate
yeah,
it.
is she understanding correctly that the importance of our statement of faith and what we believe need to be clearly stated before these issues with SOGI arise? Yes. The big answer to that is yes. Yes, it's better. I mean, it's best to have them articulated now, to be proactive about it. Of course, if you have an event, a matter arise, you can still adopt it, but being reactive can complicate things from a number of perspectives, maybe legally, certainly from a public relations perspective and optics perspective. So being
Darren,
proactive is good.
So Darren, I wonder, kind of playing off that question, let's say you don't wait till, you certainly don't want to wait till there's a problem, but if you have a situation where those on the call say, you're right, we need to get on this, and they go make a change here and, next year or early, whatever, in the next couple of months, and then something happens, would somebody come back and say, well, the parents and the faculty that you brought into the school 4 or 5 years ago were under a different document, and therefore do we need to, once we've amended it, do we need to come back and have everybody sort of re-sign, revisit, agree back to?
A best practice we recommend for schools in particular is when you do your re-enrollment process, or whatever your re-enrollment process is, to have everyone re-up on affirming or agreeing the statement of faith. And,
Okay.
That's for your students and families, and for your faculty as well each year when they re-up, if they sign the faculty manual, then to do that.
I'm often comment on the fact that I think our students in some ways are some of the most neglected part of our classical Christian population, meaning they're not often privy to an explanation of what is classical Christian education. They just get, into this process, and it just sort of happens by osmosis around them. I'm wondering, since to the questions a moment ago about students that decide to change gender and then it creates this big issue, most of schools, I mean, I don't think typically we do a very good job of presenting statements of faith and policies like we do to parents to students, because is that also part of your recommendation, that they become invested in that, I would assume?
So different schools handle that differently, but a lot of times we do recommend with the student handbook, assuming you have a student handbook or a parent, a lot of times it's a combined family handbook or parent-student handbook, that the students sign it. Particularly, I mean, the most frequent thing I will see is like 6th or 7th grade students or older, accounting for kind of the younger development aspect. So that is the best practice we recommend, is making sure the students, particularly the older students, are signing the handbook.
Exactly. Yeah. Probably not kindergartners, but right.
Yeah.
As they get a little further down the line. All right, Greg's squeezing in one more question here. Asking about high school athletics. He says he's in Washington State, 9th Circuit Court, not a friendly place. Any immediate recommended action steps in regard to athletic policies being buttoned up?
That's something else. We're happy to look at your athletic handbook or your athletic manual, and that's something we'll do. So, Greg, specifically for your school, I'd encourage you to join the Ministry Alliance, to join and send us your documents. But we definitely review athletic manuals for that purpose. And he's hitting on an important issue. These issues are kind of geographic, specific. I mean, if you're in a more favorable jurisdiction, you have a different risk assessment analysis than if you're in Washington State.
Yeah. Excellent. All right. Greg says he's joined ADF and he's going to be sending stuff your way. So heads up on that. So, all right. Well, we're at the top of the hour. I really appreciate Sherri, you, Darren, taking your lunch hour to come join us here. Very helpful, very informative. We'll definitely get this recording out so others, if you were listening and you had a colleague that couldn't make the call, you can share that with them. But thanks so much. We'll be back for future coaching calls here with the SCL. But thanks again very much, Sherri and Darren. We appreciate it.
Thanks for having us.
Thank you.
All right. Have a great afternoon, everybody. Thanks for being a part of it.